And indeed, that is consistent with the approach adopted by the Deputy Judge in Access that my learned friend took you to towards the end of his submissions. And my learned friend took you to one paragraph, but I would suggest that his analysis bears consideration beyond that.
I think he took us to the paragraph that you relied on. In fairness.
Well, I think it was my learned friend, Mr. Scory, but and I would rely on some more paragraphs, which I'm not going to read out for you just now. So this is at tab 14, page 382. That's 275 of the report, starting paragraph 54. Page 382 of the authorities project. So 54 is the paragraph that my own friend read out to you. And then, having taken that, i.e. being aware of the potential unattractiveness of inconsistency, he then goes to analyse the tower and the various excess layers and consider whether or not that inconsistency may have occurred. And I have a point to take from his analysis, but at 75 is his conclusion. And he sets out 5 principles, which I would, 6 in fact over the page, but 5 relevant principles I would adopt here. And certainly the point at 4 regarding the advantage of certainty is useful. But what he recognised in reaching the conclusions he did, and indeed that there would be fragmentation, to use the phrase from Lord Justice Thomas, is that that is open to the parties. And he recognises this at para 56, at page 382, which he perhaps states the obvious, but I would say commercially obvious, at para 56 of 382, that sometimes parties compromise. Sometimes they reach what might be described as commercially undesirable clauses or clumsy clauses to resolve a disagreement or compromise. But of course, just stepping back for a minute, what I've sought to show you is that there is no overarching paramount principle of one-stop adjudication in the fashion my learned friend has suggested, and so that doesn't help him. But secondly, and more importantly, I am mainly concerned with what my client's policy, the umbrella policy, does in the tower, which sits at the base of the tower. And while it may be, as indeed AWAC have sought to do, that the excess layers have sought to litigate in other areas, or they might have had an exclusive jurisdiction clause operative, excess 1 and 3, or not at all, excess 2. My contract is very simple. It's a contract between the Wood Group and Chubb. It is chosen, we say, under clause 11, that disputes must be litigated in London. There is no risk, as far as those parties are concerned, of a multiplicity of action, or the clumsiness, or the commercial undesirable results. That's certain, what I've suggested and what I'm submitting. And that's secure and gives, going back to the HINPRO analysis I adopted earlier from Lord Justice Christopher Clark, at the beginning of the policy, a degree of value-neutral certainty. It's only now that Wood has had the risk eventuate, because of course all policies deal with fortuities, and has made the error, we say, of seeking to litigate the insurance policy disputes in Canada. We say breaching their contract. That they are now trying to craft a permissive or floating approach. However, at the beginning of the policy, before any of these things have occurred, in the simple relationship between Chubb and the Wood Group on the umbrella, it was value neutral. There was certainty there, and it did allow the parties to know that if something does happen, where to go. So it's not an undesirable result. It isn't a multiplicity of problems here. It isn't even close to the issues that faced House of Lords in Homburg, or indeed the Court of Appeal in Deutsche Bank. So that's why I say that the one-stop shop argument is lacks credibility. It is also inconsistent with the permissive approach that's been adopted here, and I've touched on this already, so I'm not going to dwell on this in much more detail. But Mr. Stewart can't have it both ways. If he's right about the permissive analysis of how the PJCC operates, and to take my Lord Justice Phillips' points regarding, well, that could mean litigation in any area, in any jurisdiction, which I would gratefully adopt, that would create chaos. The opposite of the one-stop shop adjudication, the opposite of the certainty provided by Clause 11 in our contract, but the opposite of any sensible result, if that is the principle that he's appealing to when seeking to justify his interpretation. It also, if I understand the permissive approach to be something like this, the PJCC says, look at the primary policy. The primary policy does not determine jurisdiction because it doesn't tell you until a claim is made under it. And so in order to understand further up the tower what the proper jurisdiction is, you have to look down to the CGL and ask yourself at the time of the claim, where has the jurisdiction crystallized? Now, if that's right, then it suffers from a number of problems. The first is one of principle. If the touchstone, as I've said a number of times, is to identify the intention of the parties, it's the intention of the parties at the time of the contract. Now, while it is possible to agree certain contingent obligations, i.e. crystallized in the future, when it comes to trying to understand what the proper place for resolving a dispute is concerned, that is something that should be divined by the intention of the parties at the time, not some notional dispute that may not eventuate, or you don't know where it's going to eventuate or how it's going to eventuate. As I said, policies deal with fortuities. The other problem is if the PJC is anchored to the primary policy, i.e. that's how you identify whether a dispute has crystallized and what the jurisdiction is, that doesn't help you if there are no claims under under the primary policy. And indeed, there are another 70 policies out here. So imagine this. There's a claim under one of the motor policies, doesn't go near the CGL global policy, the primary policy, but leads to a claim under the umbrella. So using the PJCC, because there are no claims under the primary, it doesn't tell you anything about jurisdiction, because that anchor point is not attached. Equally, you may have breaches of obligations of the umbrella policy that are irrespective of the obligation to indemnify by the insurer. Let's say there's a dispute on the premium. How much has been paid, when it's been paid, has it been paid in time? So there's no claim under any of the policies underneath the umbrella. But you're left with no answer under the PJCC as to where the dispute should be litigated. Obviously, the answer, I say, is look at Clause 11. That tells you everything you need to know. Equally, when you're considering, for example, you might have multiple claims, multiple jurisdictions under the same type of risk, and all this encourages, on the theory that my learned friend is putting forward, even if it works, is a run to courts, a forum shopping, a race to secure the jurisdiction that you think, in this instance, is the most advantageous. And that cannot be a sensible commercial approach to this sort of policy, let alone this tower, with these sorts of parties. And the final point, if I may, is comity, and what my learned friend has said about that. in a simple term, comity is completely irrelevant here. Because my learned friend, as I understand it, his clients, had a claim form issued in Alberta in 2021. The life of that claim form is 12 months. That has now expired. Alberta is not seized of this action anyway. So the point, well, it may be because of the injunction, but that is the fact. So if comity, as my learned friend has suggested, about things like the management of judicial resources, making sure there isn't undue delay, respect for other jurisdictions, it's a whole bundle of various factors there expressed in the word comity.
It seems a most unmeritorious point if the injunction should not have been granted for you to rely on the fact that the Canadian proceedings have expired.
Well, it isn't if, for example, one looks at the second excess layer where there is no injunction in play. It isn't, for example, if one asked, well, what could have been done? Well, there could have been an attempt to vary the injunction in order to preserve the life of the claim form if that was necessary. Those sort of steps weren't taken. But what I'm saying is if one's looking at the comity factors, for example, the management of resources, the interference with another party's jurisdiction, and saying that is enough to overbear the terms of Clause 11, which is a bargain between the parties that we say is being breached, then the weight of comity, I'm not saying it's irrelevant, I'm not saying it should be ignored, it is part of, I actually say, the exercise of discretion as set out in the various terms by Mr. Justice Jacobs looking at the Catlin case. But the weight cannot be high in this case. It's not like, and this is what I was trying to do, the case of Ecobank and Tannock, which is of course dealing with an anti-enforcement injunction, where you've had a decision, you've had a case, you've had a waste, arguably, if it's allowed, of judicial resources. This is an issue in our case at a much earlier date. The second point is, while my learned friend appeals and relies upon the case of ANCAM, that isn't an expression of the law in this court. The problem for my learned friend, and that's whether one looks at the analysis in the Ecobank Tannock case or indeed in the Angelic Grace, is that while comity can be considered, it doesn't stop the exercise of discretion in providing or ordering an anti-suit injunction. And the reason there, and we'll look at it in a minute, if necessary, is comity is a two-way street. Arguably, the protection of jurisdiction is as much part of comity as the respect of jurisdiction. And certainly when one looks at the way that Lord Justice Millett and Angelic Grace approaches the issue, it is very much focusing on the rights of the parties between themselves under a private contract. And that is the root of the jurisdiction, or the justification for the exercise of the jurisdiction to order the anti-suit injunction in the first place. So on this final point, could I just take, my lords, to the Angelic Grace, which is in my first bundle at tab 3. And the judgment of Lord Justice Millett is at page 96 of the report 34 of the bundle. This is probably very familiar to the court already, so I'm not going to ask you to read it through, but in a nutshell, what Lord Justice Millett is properly saying, and perhaps Lord Justice Leggett put slightly more vividly in his judgment, is that as a matter of contractual rights, it's an in personam right. It is demands the exercise of the court's jurisdiction to order the anti-suit injunction. And as he says at the first highlighted section, so that's in the first column, 96, in my judgment, there is no good reason for diffidence in granting an injunction to restrain foreign proceedings on the clear and simple ground that the defendant has promised not to bring them. and then goes on to deal with other courts. This, while respect for other courts is important, it cannot overbear private agreements not to sue someone else in another country, which is why the jurisdiction, as expressed by the learned judge in this case, and as in many cases, requires a degree of certainty or degree of confidence that there is such an exclusive jurisdiction clause here, and indeed the judge was right to have come to that conclusion and have that confidence. And in EcoBank, this point is further developed, so that's at tab 10. That's at page 278, it starts in the bundle. Now, what I would like to take you through, my lords, is where Lord Justice Christopher Clark deals with the submission there was some sort of sea change in the approach on this. And in doing so, he considers a variety of different authorities, including OT Africa line, which he deals with over the page at 298, para 96, and refers to and quotes the decision of Lord Justice Longmore that my learned friend read out to you earlier this morning. The point I would emphasise, even though actually the extracts, both here and over the page, bear reading, is that at para 32, which is the recognition that where you do have an exclusive jurisdiction clause, comity has a smaller role, i.e. reflecting what Lord Justice Millett says in the Angelic Grace. And the true role of comity is to ensure the parties' agreement is respected, i.e. what's happening in this case, the decision of Mr. Justice Jacobs, far from being inconsistent with comity, was actually part and parcel of general notions of comity.
I would suspect that in OT Africa, which was concerned with proceedings in Canada, interestingly enough, Lord Justice Longmore was probably well aware of the Amchem case. Do you know if that was referred to in OT Africa?
I'm afraid I don't know, but I could find out if that would assist.
Well, I suppose we could find out for ourselves. Probably.
I'm sure you could. That's what I'd offer.
Yeah, I just wondered if you knew. Yeah.
And I would surmise he probably did. And going to ANCAM, just in general terms, relying upon the points that my learned friend read out to you, while the ultimate conclusion of ANCAM, I say, isn't consistent with English law, the general principles articulated are in the sense that comity, while it has a warm ring to it, as some people say, and while it is a two-way street, which I also will adopt, it isn't a fundamental procedural bar, for example. It isn't something that stops this court from doing, or indeed Mr. Justice Jacobs from doing what my client asked to be done, which is simply to uphold this bargain, which we say is clear, and to respect the choice of law, the exclusive jurisdiction clause at clause 11. So those are my points, my lords, unless there are any further points I can insist upon.
Can I just ask you one thing?
Certainly.
Supplemental bundle, page 91.
Would you mind if I just put my bundle away first?
It's just the page with clause 11 on it. Of course, it's also in the
Certainly.
core one.
I have that. Is that supplemental 91?
91.
Great.
I was asked about clause 10, cancellation. I'm noting that clause appears, in the terms of cancellation, appears to incorporate the terms of the primary policies as to cancellation. I was wondering whether you make anything of that.
Sorry, the reason I was pausing, I was just checking the definitions at 92 to see whether primary policies was defined in it. I don't believe it is. Well, I'm afraid I don't make anything of least nothing I think I can insist on at this stage.
Right,
Maybe
thank you.
Mr. Scory has a better answer to that question than I do. But what I would say is it certainly doesn't undermine the interpretation of Clause 11 that I put forward this afternoon.
Yes, thank you.
My Lord, AMCAM was referred to in OTF cited and referred to in the judgment. AMCAM was referred to in the judgments in OTF.
I'm grateful.
Yes, Mr.
Briefly, my lord, without repeating what's been said already, just to be clear, vis-à-vis my clients on the first and third excess layers, I am not concerned with the second ground of appeal, which is clause 11, because my clause 12 is expressly clear that it's exclusive, nor am I concerned with ground number 3, that's a Scottish point. That likewise doesn't apply to me. Therefore, I was only concerned with 1 and 4, which is the same point on construction. Can I just make clear what I'm not going to address? I'm not going to address the court on anything to do with comity or antecedent injunctions, because those aren't part of the grounds, and we've not come here to debate that. So I'll move on to the other point I'm not going to address you on, which is principles of contractual construction. Because the only caveat raised by my learned friend this morning was that he may come back to that to the extent that I did not accept one looks at a contract as a whole, and of course I do. One does construe a contract as a whole, which is why I say the front and back point goes nowhere, but it also means there's no dispute between the parties as to the approach to construction. The issue is whether the judge applied those principles correctly in this case. And the first point raised against me is that this, in some way, there's a bias, because the judge started from clause 11.12 rather than the PPJC. I say there's nothing wrong in that. Doesn't matter where one starts from, because the judge construed it as a whole, one has to start somewhere. But if one starts with the PPJC, one gets to the same result. Indeed, if one starts with the PPJC, the language of that clause may assist in indicating the exercise to be undertaken, and why talking about conflict or clauses trumping each other may not actually be helpful. If one looks at the clause itself, and this is found in a number of places, but most easily in the core of bundle 9, tab A, page 94, one sees there are 3 sentences and 3 elements to this provision. Of course, this is a reference to the choice of law and jurisdiction. It's purporting to effect a choice of law and jurisdiction positively. If one looks at the first sentence, any dispute is to be determined by the same law and same jurisdiction as the primary. Now, if one looked at that either slowly or quickly, it posits the idea that there is some provision that's being incorporated. That doesn't read comfortably, as my friend says, as some sort of reference to LIBOR, namely a reference to a third party which identifies the law. It's positing that the primary policy has a mechanism that identifies that law or contains such a provision itself. What it cannot mean is that one merely adopts whatever law somebody else has identified as being the law of that primary policy.
Well, a contract always does have a law, but it doesn't have a jurisdiction.
Oh, correct. Always has a law. This policy could have said clause 12 is deleted, and there is no choice as to the governing law, and therefore we will engage in the lottery of it being decided by whichever court is seized of jurisdiction on the dispute, which is the effect under the primary policy and is the general approach of CGL policies in the US. It didn't do that, but that's the effect of my learned friend's argument. Instead, if one looks at this provision, it's purporting positively to assist in identifying a law which is to apply, not simply saying there is no law and therefore one reverts back in this court to Article 7 under Rome 1. And it would, if that was intended to be the effect of this provision, one would have expected very different language. Because if one then looks at this, and just pause there for a moment, there's a lack of clarity with respect to the appellant. There's a lack of clarity of whether it's being said that the law applicable, the primary policy, is the law as determined by any other court seized of a dispute under that primary policy, which appears to be his case in the context of the one-stop point, so that there's one venue to determine everything, or instead whether the law of the primary policy is to be determined by this court seized of the claim under the first and third excess policies, in which case there's going to be a very different answer than if the claim were brought in Alabama or Singapore, and there may be a very different answer between the different subscriptions to each of these policies, depending upon whether the insured manages to get to court first, or whether the insurer goes and sees a negative declaration. And the idea that one can lead to that forensic Tower of Babel suggests that that wasn't the intention of this provision. And if one then looks further on, each party agrees to submit, this is the second sentence, to the jurisdiction of any court of competent jurisdiction within said territory. Just pausing there. Learned friend says that reference to territory is the territorial limits worldwide, so any court retains those jurisdiction. My first point is that doesn't help in construing a coherent clause, but my submission is that that reference to the territory is more appropriately a reference to the territory of the law identified in the prior sentence. So it's positing the idea that there is a law that identifies a jurisdiction, and then one agrees to submit to a competent court within that jurisdiction. And that leads on to the third point, which is all matters arising hereunder shall be subject to that law and that court. So the third sentence is in effect creating exclusivity with what has gone before, i.e. all disputes are governed by that law, and they will all go to the court of that law. Which is not, of course, consistent with this permissiveness, this optionality. It also means that, as before Mr. Justice Jacobs below, my learned friend is ultimately pressed to say, well, which law applies to the primary? And the Wood Group says, well, the law will be determined by this court as, under the Rome Convention. That's probably English law. And if that's English law, then one looks at that third sentence of the PPJC, and if it's going to be English law and all matters are to be determined, then that's akin to an exclusive jurisdiction in favour of this court, which means that one is entitled to the ASI in any event. So whichever way one goes, in my submission, one is entitled to the ASI which was granted in this case. I don't propose to say anything further on the 2 points raised by my learned friend, the appellants in support, namely specifically negotiated versus printed. With respect, that posits the idea there's a clash, as opposed to seeking to interpret those clauses and seeing whether there is, at the antecedent stage, a clash. In my submission, there's not, because one looks at the PPJC and there is no choice in the primary, and therefore one reverts back to clause 12, and it's a very simple analysis, and that could be a short answer. As to the one-stop shop point raised, that's in effect a public policy argument in favour of construing these provisions in a certain way. The court has the point that there may be a multiplicity of shops because one's dealing with various layers, various insurers. And if one looks at any ASI claim in the commercial court over the past 18 months, one sees the multiplicity of jurisdictions which are involved in a tower and applicable laws in the insurance context. there can be no presumption that there is either one jurisdiction or one law to govern the tower. That's simply not borne out by the commercial reality, nor, I dare suggest, the experience of the court in a prior life. And therefore, this fragmentation, that is part of the market, and that is what has happened here. I'm conscious of the time, and I don't want to repeat what's been said. Unless I can assist the court any further, I'm tempted to stop there.
No, thank you very much. Yes. How long do you think you'll need for your reply, Mr. Stewart?
I don't think any more than 20 minutes, my lord. I want to pick up some particular points.
Right. Well, this is not very convenient because it's all my fault, but I'm afraid I can't really sit as long as another 20 minutes. So I think what we will have to do is come back in the morning. Sorry about that, but I think we are listed for a second day, I believe. That's right, isn't it?
I mean, there are some points I'm afraid I do want to do.
No, you must make your reply points. I don't want to hurry you in any way, or to force you to do it in less time than you need. And 20 minutes is perfectly fair to respond. I'm sorry if it were I didn't have to be somewhere else. We'd sit and let you complete, but I do. Sorry about that. 10:30.